So, good evening everyone. We are the group 4 and we are going to discuss the other half of the topic for corporation. Let's start it with the classification of shares. Here we will know its different classification, of course, their corresponding rights, privileges, restrictions, and their stated par value, if any. And also, it must be stated in the articles of incorporations. Tulad nga sa sample na binigay namin sa inyo, makikita nyo dun yung par value ng mga shares na available sa corporation namin. And also, kailangan na equal yung each share in respect sa ibang share, except otherwise provided in the articles of incorporation and in certificates of stock. So, tulad nga sa nakikita nyo ngayon, ito yung sample ng mga rights and privileges na makukuha ng mga shareholders namin if depende yun sa binili nilang shares. And by the way guys, sorry pala sa audio ko since umuulan nung nirecord ko to, may extra background music tayo habang nag-discuss. So, let's continue. So, yung una, the ordinary or common share. Ito daw yung nagre-represent sa equity ownership sa isang corporation and give rights to the shareholders to vote in matters na may say yung mga shareholders. So, tulad ng pag mag-e-elect ng directors or trustees. And, yung mga holder ng share na to ay entitled to an equal pro rata division of profits without preference. So, ibig sabihin, proportionate allocation of profits pero hindi sila priority. So, the next one is the preference of or preferred share. Ito naman yung mga priority. Nagre-represent din sila ng equity ownership sa isang corporation pero carries no voting rights sa mga matters na may say ang shareholders, tulad nga nung example kanina sa pag mag-e-elect ng directors or trustees. Ang lamang lang naman nila sa ordinary share is that kahit na wala silang voting rights, sila naman yung priority. So, saan nga ba priority ang mga preference share or preferred share? Una, sa dividends. Kapag nagkakabayar na, syempre, bago bayaran si ordinary, mauuna si preference kasi nga, priority. So, kunwari, ito si Darwin. And ito naman si Quinling. Si Darwin ay holder ng ordinary share. Tapos si Quinling naman ay holder ng preference share. Dumating yung bayaran ng dividends. So, sino yung unang mababayaran? Syempre, si Quinling. Kasi nga, holder siya ng preference share. So, isa pa nga sa kung saan priority ang preference share ay sa kapag magli-liquidate ang corporation. Ibig sabihin, mag-i-stop na talaga ng operation. So, after mong mabayaran, yung mga outside creditor, kasi alam naman natin na sila talaga yung mga unang binabayaran kapag magre-liquidate, unang mababayaran mo naman sa shareholders mo ay ang mga preference shareholders kasi nga priority sila. So, kung gusto mong maging priority kahit minsan lang sa buhay mo, mag-avail ka ng preference share kahit sobrang daming nakapaligid dyan. Ikaw at ikaw pa rin yung uunahin. So, ang pangatlo ay may conversion privilege daw yung preference share. Ibig sabihin, pwede siyang i-convert to common share pero it will just happen if the preferred shareholder elects to do so or certain conditions are met. Wala daw share na made-deprive of its voting rights except kung ikaw ay preferred at redeemable share unless otherwise provided in this code. Diba nga, sinabi ko kanina, yung tungkol sa preference share na wala silang voting rights. And according nga sa code na to, yung mga non-voting share are still entitled to vote in these following matters. Una, amendment of Articles of Incorporation, adoption and amendment of bylaws. sale, lease, exchange, mortgage, pledge, or other disposition of all or substantially all of corporate property, incurring, creating, or increasing bonded indebtedness, increase or decrease of authorized capital stock, merger or consolidation of corporation with another corporation or other corporations, investment of corporate funds in another corporation or business in accordance with this code, and dissolution of the corporation. Ito kasi mga topic na to ay major matters na pwedeng madiscuss sa within a corporation. So, kailangan talaga may say lahat kahit non-voting or voting share yung na-avail mo. And yung preferred shares ay pwede lang ma-issue ng may stated par value, and the board of directors were authorized daw to fix the terms and condition of articles of incorporation for preference share, provided daw na magiging effective lang daw yun pag nakapag-file ng certificate with SEC. Different types of preferred shares include, una, yung cumulative and participating preferred shares. It will give the holder the right na makareceive ng una, dividends in arrears. Yung arrears daw, ito yung mga undeclared dividends in previous years. Tapos pangalawa, dividend in current years. So, if na-fulfill na yung pagbibigay mo ng dividends in arrears, tapos nabigay mo na din yung dividend in current year for preference shareholder, pwede mo na ding bigyan ng dividend in current year si ordinary share. Tapos yung pangatlo, pwede pa siyang makatanggap ng additional dividend. Ito, yung additional dividend, pag nabigyan mo na ng dividend for current year si ordinary share, tapos may natira pa, bigay mo ulit kay preference. Kaya nga additional dividend. Kasi hindi naman siya yung dapat matatanggap niya for current year. Pangalawa, cumulative and non-participating preferred shares gives the holder the right to receive the dividends in arrears tsaka dividend in the current year. Yung pangatlo, non-cumulative and participating preferred shares, ito naman, nagbibigay sa holder ng right na makatanggap ng dividends in the current year and additional dividend. Si non-cumulative and non-participating preferred shares gives the holder the right to receive only the dividend for the current year. Yung panglima, yung convertible preference share. It gives the holder the right para ma-convert yung preference share to ordinary share or some other securities of the corporation. Yung F, yung redeemable or callable preference share. Ito naman, gives the issuing corporation to buy back the share with a specific call or redemption price and a date on or after. And the next type is the par value share. So, sobrang obvious na, no? Ito yung share na may specific money value fixed sa article of incorporation and appears in the certificate of stock. Next one is the no par value share. Ito naman yung walang stated par value appearing sa certificate of stock. Has the same rights then with the holder ng par value share. Kunyari, kung ano man yung rights na meron yung holder ng par value share, ganun din yung rights na makukuha ng holder ng no par value share. So, kapag wala par value yung shares ng capital stock, tinitreat na natin siya as fully paid and non-assessable. And yung holder ng share na to shall not be liable to the corporation or to its creditors. And yung no par value na share must be issued for consideration not less than 5 pesos per share. And yung na-receive ng corporation for its non-par value shall be treated as a capital and not available for distribution as dividends. Ito namang watered share. Ito yung mga share na issued at price na nag-exceed to its true value. Yung totoong worth niya ay mas mababa kaysa dun sa binayad na investment capital. Itong voting share and non-voting share, sobrang obvious na. Yung una, entitled ka para bumoto sa mga meetings. And yung latter naman ay wala kang voting rights. And the next one is the treasury shares. Ito naman yung stock na na-issue na and na fully paid na. Pero can be reacquired by the issuing corporation. Paano ba siya ma-reacquire? So, through purchase, redemption, donation, and some other lawful means. Pero, pwede mo ulit itong ibenta by the reasonable fixed price by the board of directors. And FYI, yung treasury share, walang voting rights hanggang mag-remain siya as treasury. So, paano siya magiging hindi treasury? Siyempre, pag binenta ulit, balik ulit siya as ordinary share. Di na siya considered as outstanding share kahit na part siya ng subscribed stock. Bakit naman ganon? Kasi, si treasury stock is a contra-equity account na nagre-represent siya ng mga repurchase sa open market. Then, ibabawa sa shareholders' equity. They are not entitled for dividend since di naman na siya outstanding share, so wala nang karapatang makaget ng dividends. They again be disposed. So, pwede ulit silang mag-dispose tulad ng sinabi ko kanina. Bakit ba binibili ng issuing corporation yung mga nabenta na nilang stock? So, probably because of yung stock trading nila is below its intrinsic value. Ibig sabihin na bumababa na yung value ng share nila, and since may excess naman silang cash, pwede nilang pambili yun. Ang next na type ay ang founder share. Ito ay yung share na granted sa mga founders ng corporation. Ibig sabihin, sila yung nagtatag ng corporation na yan. Merong mga certain rights and privileges sila na di natatamasa ng ibang shareholders. It must be classified sa articles of incorporation. And ano nga ba yung tinutukoy na rights and privileges na yun? Yun yung to vote and to be voted para sa election of directors. Pero, may limitation yung rights na yun. May limit period yun, not exceeding 5 years from the date of incorporation and subject to the approval of SEC. Dito ma-allow if mabaviolate niya itong mga batas na to. Una, Commonwealth Act No. 108, otherwise known as Anti-Dummy Law. Pangalawa, Republic Act No. 7042, otherwise known as Foreign Investments Act of 1991, and pertinent laws. And lastly ay ang redeemable share. It is grant naman sa issuing corporation the power to redeem or purchase them after a certain period. Pwede siyang ma-issue ng corporation kapag expressed on its article of incorporation. Yung holder ng share na to may be deprived of its voting rights. Pwede lang siya ma-purchase in corporation upon expiration of fixed period, regardless kung may unrestricted retained earnings sa book ng corporation, and kung ano nakasulat na terms and conditions sa articles of incorporation and certificate of stock.
And now, let's move on to our next topic, which is majority and minority control. Or I must say, majority powers and minority rights. Bakit ko nga ba nasabi yun? Pero bago yan, let us first differentiate the difference between majority shareholders and minority shareholders. So when we say majority shareholders, they are the ones who owns 50% or more of the company shares. They are the one who ruled the decision making. Ibig sabihin, meron silang say sa lahat ng desisyon na gagawin ng company. And they have the benefit of voting and election privileges. Ibig sabihin, pwede silang bumoto at iboto. and they are consistently updated about how the company is performing. At kung di sila masaya, they can request an election for new board members. Ang bongga, diba? And based on the revised corporation code, here are some of where majority shareholders vote are needed. Ang mga mababanggit ko ay maaaring na-report na or ire-report pa lang ng mga reporters. Una, amendment of Articles of Incorporation, election of directors or trustees, vacancies in the office of director or trustee, compensation of directors or trustees, power to extend or shorten corporate term, sale of other disposition of assets, power to enter into management contract, and lastly, adoption of bylaws. Since na-discuss na natin yung majority, dumako naman tayo sa minority. Kanina, pag sinabi nating majority, they are the one who owns 50% or more of the company shares. Dito naman sa minority, they are the ones who own less than 50% of the company's outstanding shares. Pero, meron din silang mga karapatan. Based on the Code of Corporate Governance, minority shareholders have 6 basic rights. Una, voting right. Pwede silang bumoto. Yun lang, hindi silang pwedeng ma-elect or iboto. Pangalawa, preemptive right. Pag sinabi nating preemptive right, ito yung karapatan ng existing shareholder na mag-purchase ng newly issued stock bago pa man ito i-offer sa ibang investors. Pangatlo, power of inspection of corporate records. So, pwede silang mag-inspect ng corporate records. 4. Right to information. Pwede silang mag-request ng information about the company. And then, right to dividends. Pwede silang makatanggap ng dividends if there is a distribution. Number 6. Appraisal right. Pag sinabi nating appraisal right, ito yung karapatan ng dissenting stockholder. Pag sinabi nating dissenting stockholder, ito yung mga taong hindi nag-consent dun sa ginawang action ng corporation. Kaya, meron silang karapatan or mag-demand ng appraisal and payment of the fair value of his stocks from the corporate. Bakit nga ba nangyayari ito? Madalas nangyayari ito kapag may merger. One corporation acquires all of the assets and liabilities of another corporation. So, may new corporation na. At makakatanggap yung minority shareholder ng shares dito. Pero, di ka makakatanggap or yung shareholder di makakatanggap ng pera or cash dun sa merger. However, kung di ka satisfied dun sa merger or mga conditions, may karapatan kang mag-appraise or may karapatan kang i-appraise yung share mo and force the existing corporation to pay you the fair market value in cash in exchange of your shares. Gets ba? So, since na-differentiate na natin yung pagkakaiba ng majority and minority, pumunta na tayo dun sa tanong ko kanina kung bakit ko nga ba nasabi na instead of majority and minority control, mas bagay siya as majority power and minority rights. Bakit ko nga ba nasabi yon? Based kasi sa nabasa ko, since sobrang powerful ng majority shareholders, they tend to be oppressive towards the minority shareholders. At dahil doon, minority shareholders suffer a loss. Kaya dahil dito nagkaroon ng Companies Act of 2013 to protect the minority shareholders. And then, Revised Code of Corporation introduced several amendments and new provisions to improve the protection of the minority shareholders. So una, companies vested with public interest. Dito, required na magkaroon ng at least 2 independent director na aprobado ng at least 2/3 of the entire membership with at least a majority of the independent directors. And dito, kailangan mag-submit sila ng director's compensation report, director's appraisal, or performance report sa SEC. Pangalawa, director's compensation. Dito, sa Revised Code of Corporation, yung directors or trustee ay di na pwedeng mag-participate when it comes to determining the daily allowance or compensation. Then number 3, information to stockholders or members. Dito, sa Revised Code of Corporation, required ang mga board of directors and trustees na mag-present ng maraming impormasyon kapag may meeting na nangyayari. Then, number 4, election or removal of directors. Kapag nag-apply yung stockholders for an election, di pa rin ito nangyari within 30 days, papasok na naman yung SEC para i-hold yung election of directors kapag napatunayan na walang naganap na eleksyon. The next, sa voting. So dito sa Revised Code of Corporation, pwede na umattend or bumoto through remote communication. Pag sinabi nating remote communication or absent siya, ibig sabihin absent siya. Char. Not physically present, but virtually. Gaya ng teleconference or video conference, which is good lalo na sa panahon natin ngayon. Then, sa letter B naman, dito pwede na rin umattend ng meeting kahit di ka notified as long as sinabi mo sa una pa lang na yung purpose ng pagpunta mo doon is to object to the transaction kasi the meeting is not lawfully called or convened. Next. Calling of meetings. Kapag walang namamahala or yung taong inassign refuses to call a meeting, tapos merong nagpetition na stockholder or member, dun na naman papasok si SEC to order the holding of a meeting. Then, maintenance of corporate records. Sa Revised Code of Corporation, mas lumawak yung list of corporate records. Included na dun yung ownership and group structure, intra-group relatives, ownership data, beneficial ownership, and a record of all business transaction. Next, conflict of interest. Pag sinabi nating conflict of interest, directors or trustees who have potential interest in any related party transaction must recuse themselves from voting on the approval of the related party transaction. Pag sinabi nating recuse, ito yung pagtanggi mong pagboto para maiwasan yung conflict of interest. Next, inspection of records. Kung dati, pwede lang yung minority shareholders na mag-copy ng mga papeles ng corporate records, sa Revised Code of Corporation, pwede na silang mag-reproduce ng corporate records. Then, kapag yung corporation di pumayag doon sa inspection and reproduction na gusto ng member, pwede silang mag-report sa SEC Then sa loob ng 5 araw from the receipt, magkakandak yung SEC ng inspection. Then lastly, SEC power. So you can see naman kanina, palagi ko siyang nababanggit. Kasi whenever majority shareholders overpower the minority shareholders, papasok dun si SEC. So sobrang powerful ni SEC dito sa revised code of corporation. At ngayon, ay dumako naman tayo sa non-stock corporation. Pag sinabi nating non-stock corporation, ito yung corporation that do not issue stocks and therefore wala itong shareholders. At dahil wala itong shareholders, it is owned by its members. And then, ang lahat ng malilikom na pera ng isang non-stock corporation can only be issued for the furtherance of its purposes. Kung para saan nga ba ang pagtayo ng isang non-stock corporation. And non-stock corporations may be formed or organized for charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, civic service, and any combination. Next naman is foreign corporation. Pag sinabi natin foreign corporation, ito yung corporation that is formed, organized, or existing under any laws other than those of the Philippines. Inaalaw nito ang mga Filipino citizen and corporation na magsagawa ng business sa Pilipinas at sa ibang bansa. Ano nga ba ang pagkakaiba nito sa domestic corporation? Pag domestic corporation, nagpatayo ka ng corporation sa Pilipinas at sa Pilipinas lang ito iikot. While kapag foreign corporation, nagpatayo ka ng corporation sa Pilipinas, tapos i-incorporate mo ito sa ibang bansa. Just want to share yung nabasa ko. Many people choose to incorporate in their home state. However, if your corporation will not do business in the home state, it may be wise to incorporate elsewhere. That would be all. Thank you.
Now, let's talk about corporate bylaws. But before that, inote muna natin na yung one-person corporation or the OPC is not required to submit and file corporate bylaws. So, dito tayo sa kung ano ba yung bylaws. Bylaws are the rules of action adopted by the corporation for its internal regulations and for the government of its officers and its stockholders or members. Until amended or repealed, the bylaws are continuing rules for the government of the corporation and the individuals composing the corporation. So, sinabi na dyan, yung bylaws daw are rules adopted by the corporation sa kanyang internal regulation para i-govern yung officers and stockholders or member. Tapos yung bylaws is a continuing unless amended or repealed or kapag merong inadapt na bagong bylaws. Paano ba natin mababalidate ang bylaws? What should we do if we are the corporation? And when will it take effect? So, ngayon, dito naman tayo sa adoption of bylaws, which has 3. Voting, signing, and filing. So, unahin na natin yung voting. The affirmative vote of stockholders representing at least majority of outstanding capital stock or at least majority of members in case of non-stock corporation is necessary. 2 is a signing. So, bylaws shall be duly signed of stockholders or members who voted, and the bylaws shall be kept in the principal office of corporation, subject to inspection of stockholders or members during office hours. Yung sa filing naman, a copy of bylaws which is duly certified by a majority of directors or trustees and countersigned by Secretary of Corporation shall be filed with the Commission or the Securities and Exchange Commission and attached to Articles of Incorporation. Ito note, sa lahat ng bylaws, all cases, effective lang ang bylaws upon the issuance of commission na yung ginawa at yung pinagkasundaang bylaws is in accordance with this code or with the law. Ngayon, mayroong exception sa bylaws, sa pag-a-adapt ng bylaws and sa pag-take effect ng bylaws. Yung special corporations like financial institutions, public utilities, and such, which is governed by special law, shall not file bylaws or amend thereto if walang accompanied na certificate ng appropriate government agency that such bylaws or amendment are in accordance with the law. So, kailangan yung mga special corporation, meron silang certificate na binigay ng appropriate government agency na yung bylaws na ginawa nila is in accordance with the law. Bago nila yon i-file or i-amend. Nalaman na natin how to adapt bylaws, which is to vote, to sign, and to file. And kung paano siya mag-take effect. And naman, let's move to the bylaws itself. Ito yung mga common na makikita nyo sa content ng bylaws. So, letter A, time, place, and manner of calling ng regular or special meetings ng BODs and trustees. Letter B, time and manner of calling and conducting meeting and mode to notify stockholders or members. Letter C, the required quorum o yung minimum numbers of members or stockholders to make judgment or conduct business and the manner of voting therein. Letter D, the modes and how to attend and cast votes. Letter E, yung mga form of proxy, kung kamag-anak ba, kaibigan, kapamilya, and the manner of voting ng proxy. Letter F, BODs and trustees qualification, duties and responsibilities, guidelines for setting compensation, and maximum number of other board representations or yung mga representative or proxy. Next is letter G, kailan yung annual election of BOD or trustee and paano yun ipapaalam sa iba. So, letter H, manner of election, paano mag-elect or appoint and yung termino ng officers na ma-elect. Letter I, penalties if violate yung bylaws. J, in case of stock corporation, so para sa stock corporation, paano i-issue yung kanilang certificate of stock. And letter K, such other matters as may be necessary for proper and convenient transaction of corporate affairs to promote good governance and anti-graft and corruption measures. Natapos na natin yung adoption of bylaws and the contents of bylaws. Ngayon naman, dumako na tayo sa last topic under bylaws, which is the amendments. A majority of board of directors or trustees and the owners of at least a majority of the outstanding capital stock or at least a majority of members of a non-stock corporation at a regular or special meeting may amend or repeal bylaws or adopt new bylaws. The owner of 2/3 of outstanding capital stock or 2/3 of member of non-stock corporation may delegate to BOD or Board of Directors or Trustees the power to amend or repeal bylaws or adopt new bylaws. Yung power na dinelegate sa BOD or trustee ay pwedeng i-revoke kapag may stockholder owning or representing majority of capital stock or majority of members of non-stock corporation voted so at a regular or special meeting. Whenever there is an amendment or new bylaws, it shall be filed with the Commission duly certified under oath ng Corporate Secretary and ng majority of directors and trustees. Take note, again, amended or new bylaws is mag-take effect lang if may certification na galing SEC or the Securities and Exchange that the said bylaws is in accordance with this code or other relevant laws. And that's it. Ayan yung under ng bylaws.
Good day everyone, this is Zero Annalie and I will going to discuss the kinds of meeting that may be had by the stockholder or members. And these are the regular meetings of stockholder or members and the special meeting of stockholders or members. And regular meetings of stockholder or members shall be held annually on a date fixed in the bylaws, if not so fixed on any date after April 15 of every year, as determined by the Board of Directors or Trustees. Written notice of regular meetings may be sent to all stockholders or members of record through electronic mail or such other manner as the Commission shall allow under its guidelines. And last is a director, trustee, stockholder, or member may propose any other matter for inclusions in the agenda at my regular meeting of stockholders or members, while in special meeting of stockholder or members shall be held at any time deemed necessary or as provided in the bylaws, that at least 1 week written notice shall be sent to all stockholders or members, unless a different period is provided in the bylaws, law, or regulations. And last is stockholder or member may propose the holdings of a special meeting and items to be included in the agenda. So, the first question is when the regular or special meetings happen. Remember that in regular meeting, it happened annually on a date fixed in the bylaws. Remember that if not so fixed, it will happen on any date after April 15 as determined by the board. How about special meetings? For special meetings, it will happen anytime. Remember, anytime deemed necessary or as provided in the bylaws. Now, the next question is saan naman or where the meeting does happen. The meeting happens in the case of regular meeting by stockholder or member in the principal office of the corporations. So, paano naman pag di kaya sa principal office? So, if not practicable, remember, in the city or in the municipality where the principal office is located. This rule is also applies in special meetings. Again, it is held at the principal office of the corporations or at the city or municipality where the principal office is located. Next is how about the notice requirement? Remember, the notice of requirement should be given, number 1, in case of regular meetings of stockholder or members within the period provided in the bylaws through email or electronic mail. The same rules applies in special meetings, but if there is no such provisions in the bylaws, at least 21 days prior to the meeting. In regular meeting, however, in special meetings, at least 1 week. Remember, 1 week prior to the meeting. The presiding officer in the regular meetings is the person designated in the bylaws. If none or no person designated, remember, the chairman is the presiding officer. In his absence, the president will preside. The same was applied in special meetings. During the meetings, pwede nilang pag-usapan yung mga agenda nila regarding their business. In regular meetings, the board of directors or trustees shall present to the stockholders or members the following. This is the new portion of these provisions and nilagyan nila ito at medyo madami ito actually. So sa letter A, bago pala mag-umpisa yung meeting, kailangan nilang i-present yung minutes of the most recent regular meetings, So in short, it will talk about the past meeting. This would include the voting and the vote tabulation procedures used in the previous meeting, descriptions of the opportunity given to the stockholders or members to ask questions, and a record of the question asked and answers given. And next is the matters discussed and resolution reached. And what else? The record of voting's results for each agenda item and such other item that the SEC may require in the list of who attend the meetings. So the next matters that the board has to present is letter B, a member list for non-stock corporations. For stock corporations, material information on the current stockholders and their voting rights. Letter C, the corporation performance, detailed, descriptive, balanced, and comprehensible assessment. Include information on any material change in the corporation's business strategy and other affairs. Letter D, a financial report for the preceding year. A statement on the adequacy of the corporation's internal controls or risk management system. And a statement of all external audit and non-audit fees. In letter E, an explanations of the dividend policy and the fact of payment of dividends or the reasons for non-payment thereof. Letter F, the profiles of directors nominated in seeking elections or re-elections. And letter G, director or trustees profiles which shall include their qualifications and relevant experience, length of service, trainings, and continuing education attended, and their representation in other corporations. Next is appraisals and performance reports for the board and the criteria and procedure for assessment, and a director or trustee's compensation report prepared in accordance with this code and the rules. The commissions and director disclosures on self-dealings and related party transactions, and last but not the least is a director or trustee's attended report of the meetings of the board and its committees and regular or special stockholder meetings. In special meetings, di ko na ito babasahin, explain ko na lang. So, sa special meetings, pwedeng i-waive ni stockholder or member yung notice of meeting either expressly or impliedly. Pero hindi allowed yung pag-waive ng general waivers na nasa Articles of Incorporation or bylaws, provided further that the attendance at a meeting shall constitute a waiver of notice of such meeting. Meaning, sa mismong attendance sa mismo makikita kung sino yung mga nag-waive ng meeting. Except when the person attends the meeting for the express purpose of objecting to the transaction of any business because the meeting is not lawfully called or convened. So, ibig sabihin, except dun sa taong matan lang para tignan yung transaction ng business dahil yung meeting is not lawfully convened. And dito sa special meeting, sinasabi dito sa unang box na nasa baba is walang person authorized na basta-basta na lang magre-refuse to call a meeting. And sa second, dahil doon sa not lawfully meeting, the commissions may issue upon showing a good cause by petitioners an order directing the petition's stockholder or member to call a meeting of he corporations by giving proper notice required by code or bylaws. And yung sa last part, the petitioner shall preside or manguna ng meeting until at least majority of stockholder or member have chosen among themselves as a presiding officers. So, bago mangyari yung meeting na in-order ni commissions, i-close muna for at least 20 days sa regular meetings and at least 7 days naman sa special meetings, yung stock and transfer book or memberships book. And yung sinasabi dito sa lower part is, how about pag na-postpone yung regular meeting? Dapat may written notice tayo and reasons na isasend to all stockholders or members at least 2 weeks naman bago yung meetings. Remember na at least 20 days sa regular meetings and at least 7 days sa special meeting, i-close yung books. And pag may nangyari postponement and kailangan natin mag-send ng notice at least 2 weeks bago yung meeting. And dito sinasabi dito sa first part is the commission shall issue the rules and regulations governing participations and voting through remote communications or in absentia, taking into account the company's scales, number of stockholders or members, structures, and other factors consistent with the protections and promotions of shareholders or members meeting. So, the place and time of meetings of stockholders or members. Kung matatandaan nyo is nabanggit ko na to kanina, and yung place nga is at principal office of the corporations, but pag hindi kaya is pwedeng sa city or municipality kung saan nakalocated yung corporations, and any city or of municipality sa Metro Manila, Metro Cebu, Metro Davao, and other metropolitan areas is considered a city or municipality for the purpose of meeting. Yung mga nakapaloob sa notice of the meeting are the followings. A. The agenda for the meeting. B. When attendance, participations, and voting are allowed by remote communication, or in absentia, the requirements and the procedures to be followed when a stockholder or member elects either options, and a proxy which shall be submitted to the corporate secretary within a reasonable time prior to the meeting. And last is when the meeting is for the elections of directors or trustees, the requirements and procedure for nominations and elections. And nakapaloob din dun sa notice of the meeting is yung time, place, and purpose of the meeting, and all the proceedings and any business transacted at a meeting of the stockholders or members, if within the powers or authority of the corporation, shall be valid even if the meeting is improperly held or called. Quorum in meetings. Unless otherwise provided in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporations. Pag sinabi natin na quorums, we're still talking about the meetings. Yung formula sa quorum is 50% or 1/2 plus 1. And pag sa non-stock corporations, it represents the majority of all the members. And next is in regular meetings of directors or trustees. Sa regular meetings of board of directors or trustees is dapat kailangan monthly yung regular meetings unless bylaws provided or otherwise, while in special meeting of board of directors or trustees may be held at any time pag pinatawag sila ng president or as provided by the bylaws. Pagdating sa quorum, nabanggit ko na yun kanina and alam nyo na yan, which is sila yung needed sa pagtransact ng corporate business, and sa bawat decision made, shall represent by quorum or yung mga may holdings na majority from outstanding capital stock. Except na lang sa pag-vote ng officers, which is required a vote of majority ng members even if not part of the quorum. And meetings may be held anywhere in or outside the Philippines unless the bylaws provided otherwise. Notice of regular or special meetings stating the date, time, and place of meeting must be sent to every director or trustees at least 2 days prior to the scheduled meeting. A director or trustees may waive this requirement either expressly or impliedly, and who cannot physically attend or vote at board meetings can participate and vote through remote communication such as video conferencing, teleconferencing, or other alternative modes of communications. Directors or trustees cannot attend or vote by proxy at board meetings. Ibig sabihin lang yan is sa special meeting kasi pwede kahit outside or inside the territory of the Philippines yung meeting. Compare sa regular meetings na dapat within the city or municipality lang kung saan nakalocated yung business. Dito, ganun rin sa regular meetings na dapat sa special meetings ay sinisend din yung notice of the meeting. Pinagkaiba lang is that dito, 2 days bago yung meeting, sinisend yung notice of the meeting. Dito, pwede rin i-waive yung notice of the meeting. And sa last part ay sinasabi dyan na kung hindi talaga makaka-attend yung director or trustees physically, pwede naman sila mag-vote through remote communications like video conferencing, teleconferencing, or etc. Next is who shall preside at meetings. So, nabanggit ko na yan dun sa first part ng aking report. So, yung magre-preside sa meeting is yung chairman. Pero pag absent si chairman is si president. Unless na lang kung provided by laws. Next is right to vote of secured creditors and administrators. The stockholder grantor shall have the right to attend and vote at meetings of stockholders unless the secured creditor is expressly given by the stockholder grantor such right in writing which is recorded in the appropriate corporate books. Ibig sabihin lang dito sa right to vote of secures creditors and administrator is my right to vote sa executors, administrators, receivers, and other legal representatives which is duly appointed by the court or on behalf of the stockholder kahit na walang written proxy. So next is the voting in case of joint ownership of stock. Sinasabi lang dito na kailangan ng consent ng mga co-owners sa pag-vote ng shares of stock na pinanghahawakan ng 2 or more persons. Unless na lang kung may written proxy na pirmado ng mga co-owners na no need na ng consent para makapag-vote ng shares, provided that when the shares are owned in an and are capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy therefore. And last, for my topic, pagdating naman sa voting right for treasury shares, wala siyang voting right hanggat yung shares niya is treasury shares pa rin. That's all. Thank you.
Good evening, everyone. Hello. I'll be discussing about the effects of obligation. So, just want to clarify lang na itong obligation na to is not pertaining doon sa liability in terms of money. Okay, itong obligation na to is tumutukoy sa obligasyon, duties, or responsibilities. So, let's start with first, the shareholders. So, si shareholders, sa kanila nagre-rest yung ultimate control sa isang corporation. Hindi naman lingid sa ating kalaman na once na you have that ultimate control, kakibat nun is malaki ring responsibilidad. So, isa sa mga responsibilidad nila is they elect the members of the board of directors according to Section 23 of Revised Corporation Code. So, next is the board of directors or trustees. So, si board of directors or trustees, sila yung nagre-represent ng stockholders or members sa affairs ng isang organization or corporation. So, they are responsible for the formulation of the overall policies of the corporation and the exercise of corporate powers. The board elects a president, treasurer, and secretary according to Section 24 of RCC. So, third is the president. So, si president naman is they shall preside at all meetings of the directors or trustees as well as of the stockholders or members unless the bylaws provide otherwise according to Section 53. So, si president, siya lang yung tanging officer na nire-require ng law na maging member of the board of directors or trustees. Pero, he cannot act as president and treasurer or president and secretary at the same time. Okay. So, next is the treasurer. So, si treasurer naman is they are entrusted with the authority to receive, keep, and disburse as he may be authorized. So, and lastly, the secretary. Secretary, he has the duty to make and keep records with regard to proceedings of meetings, resolutions and votes of stockholders and members, and directors in the management of the corporation and all other matters required to be entered on the record. So, si secretary, sila yung madalas mong nakikita sa bawat meeting ng board of directors na nasa gilid, naglilista ng mga napag-uusapan doon, and etc. etc. So that would be all for the effects of obligation. So let us now proceed with the corporate reorganization. So I'll give you muna some overview about it. So alam ko namang medyo may idea na kayo dito since napag-aaralan na natin siya sa ADVAC. So just want to review lang. So isang corporation is pwede siyang humantong sa isang financial difficulty for a large variety of reasons. So, a company may suffer from continued losses from operations, overextended credit to customers, poor management or working capital, failure to react to change in economic conditions, meaning hindi sila nakakasunod sa trend. The next is inadequate financing, and a host of other reasons for not sustaining a viable economic position. So once na naka-experience na yung isang corporation ng ganitong kalagayan with regards to financial, nagsisimula na silang mag-fail to make sufficient amount of sales. A company cannot obtain enough financing anymore. Then, magsisimula na rin silang makamiss ng mga bayarin nila sa utang, and the cycle of financial difficulty is underway. So, at this point, yung outside creditors nila may decide na to exercise their claims and demand payment of their debt. Then, si debtor, maraming siyang alternative courses para mabayaran yon. It may take a legal remedy for bankruptcy. Meron siyang dalawang choices, which is, first is turn its assets over to its creditors to liquidate, which is liquidation. And second is try to reach an agreement with creditors, which is the corporate reorganization. So kung ang isang corporation ay naging insolvent, it don't necessarily mean na hanggang doon na lang. Because as an alternative to dissolution and liquidation, a corporation in financial difficulty may attempt to rehabilitate through reorganization. So meaning, itong corporate reorganization is their second chance. So ano nga ba yung ibig sabihin ng reorganization? Means the implementation of a business plan to restructure or rehabilitate a corporation with the hopes of increasing company value. So from the word itself, reorganize, meaning ino-organize mo ulit. May ginagawa ka sa company mo para ma-increase yung value. It is different from liquidation kasi sa liquidation, you're already terminating the business. Dito kay reorganization, you are doing something, nag-reorganize ka sa company mo para yung value niya is tumaas. So mostly, ang involved na binabago dito is yung capital structure ng isang entity. So this is also an arrangement entered into with creditors to reorganize the company and return its operation to a profitable level. So the control is normally retained by the ownership, and SEC may appoint a trustee para maiwasan yung fraud and also to protect the interest of the creditors or stockholders of the company. Various reasons why corporations undergo with reorganization. So maraming dahilan. And itong insolvency is isa lang siya sa maraming dahilan na yun. So example sa mga situations na kung saan or kailan nangyayari itong corporate reorganization. So first, buyouts and takeovers or threats. So for example sa buyouts, si company A, bet niyang bilhin si company B. So, ayun, binili. Then, dito naman sa takeovers, for example, si government, may something siyang nakikita na ginagawa itong isang corporation na to. So, nag-decide siya na iti-take over niya na lang yun. So, in that situation, may reorganization na mangyayari doon. So, next is business combinations, reverse acquisition, sale or transfer of subsidiaries, and demergers. So, meaning nagko-combine yung business, and ayun, may reorganization din doon. So, C, formation of new holding company when the new holding company is a vehicle for enlisting shares in a stock market while the business remains with the subsidiaries. So, for example, ng mga holding companies is SEBA, CBN Holdings, and etc. etc. So, next is recapitalization, changing the company capital structure. And last is an insolvent corporation enters into a corporate rehabilitation program. So, ito na yung pinag-uusapan natin kanina na instead of terminating, pinili nilang ayusin na lang or baguhin na lang yung structure ng organization nila. So, just because the company is experiencing insolvency doesn't mean na automatically terminate na agad. Cause may second chance pa, may pag-asa pa. Yun ay kung willing yung corporation. So, next is plan for reorganization. Should be submitted by the management to the company's creditors and stockholders and to SEC for approval. So, ito yung inclusions ng plan nila. So, next is si SEC, i-review yung plan na yun. So, bago ito ma-confirm ng SEC, it must be accepted ng majority ng mga creditors and yung mga stockholder na nag-own at least 2/3 of the outstanding capital stock is dapat in-accept din yun. So, kung sakali lang na some of the stockholders and creditors ay hindi pumayag, the SEC may confirm the plan if the plan is fair and equitable to the non-acceptors. So yung confirmation ng SEC dun sa plano or organization is yun yung magbabind sa debtor company on all creditors and stockholders. So let's now proceed with the types of corporate reorganization. The following are some of the types of corporate reorganization. So first is group reorganization. So ito yung parang kinumbine lang yung tatlong example kanina. So ownership within a group of companies changes. Maaring due dun sa new acquisitions, buyouts, takeovers, and etc. So second is recapitalization. Change in capital structure through the replacement of old shares with new shares. So paano nga ba yun? For example, par to no par, i-change mo yung stated value of shares or pwede rin yung share split. Pwedeng pataas or bababa. So third is quasi-reorganization. A financially troubled corporation revalues its assets and liabilities and realigns its equity. So kung malalaman mo kung i-revalue ba natin tong asset natin, may pambayad ba tayo sa utang natin, liquid pa rin ba, ganun. Fourth is corporate rehabilitation. So gaya ng sabi natin kanina, just because the company is experiencing insolvency doesn't mean na automatically terminate na agad. So may mga times kasi na si corporation is willing pang ituloy yung business operation niya. So instead na terminating the business, rehabilitation yung solution. So a financially troubled corporation is administered by another party in order to try to bring back the corporation to its former condition. And lastly, troubled debt restructuring involves the settlement of obligation that other than the originally agreed method of settlement. So for example, approaching na yung bankruptcy sa isang corporation. Marami silang asset pero hindi sila liquid, like wala silang cash na pambayad sa mga utang nila. So with that, makikipag-usap sila sa mga creditors na enough naman yung asset ko pero wala akong cash, hindi ako liquid. Ayan, debt restructuring. So pag-uusapan nila yung utang para magkaroon ng new agreement as to how this utang or that utang is going to be paid. So that's all. Thank you.
Good evening, everyone. I will discuss about the methods of dissolution, which is under Section 133 of the Revised Corporation Code of the Philippines. So, kapag sinabi naman nating dissolution, it means the termination of the existence of a corporation or ng isang business. A corporation formed may be dissolved voluntarily or involuntarily. Now, let's talk about the kinds of dissolution under voluntary. The dissolution may be said to be voluntary where no creditors are affected if hindi ito against sa right ng kahit na sinong creditor. Second, it is based on the majority vote of the Board of Directors, and there is a resolution na nagpapatunay na majority of the members or stockholders also owning at least majority of the capital stock voted or nag-agree. Paano nga ba yung process bago ma-dissolve ang isang corporation? So, at least 20 days prior to the meeting, lahat ng shareholders ay makakatanggap ng notice, regardless kung entitled silang mag-vote or hindi during the meeting. Yung purpose ng meeting is to vote on the dissolution ng corporation. About naman sa time, place and object ng meeting, pinapublish yon prior to the date ng meeting sa isang newspaper kung saan located yung principal office ng corporation. After that, when the dissolution request is verified, ipa-file na yon sa commission. And stated dun sa request, itong mga sumusunod. The first one is the reason for the dissolution, the form, manner, and time when the notices were given. C. Names of the stockholders and directors or members and trustees who approved the dissolution. D. The date, place, and time of the meeting in which the vote was made, and E. Details of publication. Ito naman yung mga kailangang isubmit ng corporation sa commission. 1. A copy of the resolution authorizing the dissolution, certified by a majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation. 2. Proof of publication. 3. Favorable recommendation from the appropriate regulatory agency when necessary. So, within 15 days from the receipt of the verified request for dissolution, the Commission will approve the request, then mag-i-issue sila ng Certificate of Dissolution. Hanggat hindi pa sila nag-i-issue ng certificate, the dissolution shall not take effect. Take note that no application for dissolution of banks, insurance, trust companies, and etc. Kasi hindi na to under ng Revised Corporation Code, under na siya ng Republic Act number 7653. Other finance intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency. If the dissolution of a corporation may prejudice the rights of any creditor, it is said to be a voluntary dissolution where creditors are affected. Here's the procedures and contents of petition. A verified petition for dissolution shall be filed to the Commission and signed by the majority of the Board of Directors, and kailangan verified siya ng President or Secretary or kahit ng isang trustees ng corporation. The dissolution was resolved upon by the affirmative vote of the stockholders holding at least 2/3 of the outstanding capital stock or at least 2/3 of the members entitled to vote. The petition shall likewise state the following: A. The reason for the dissolution. B. The form, manner, and time when the notices were given. And C. The date, place, and time of the meeting in which vote was made. The corporation shall submit to the Commission the following: 1. A copy of the resolution authorizing the dissolution, certified by a majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation. And 2. A list of all its creditors. If the petition is sufficient in form and substance, yung Commission, magsiset siya ng deadline for filing objections. The date shall not be less than 30 days nor more than 60 days after the entry of the order. So, bago dumating yung date na yan, dapat yung copy ng order is nakapublish ulit sa newspaper kung saan located yung principal office ng corporation or in a newspaper of general circulation sa Pilipinas. So, kapag nag-expired na yung allocated time for the right to file objections, magkakaroon na ng hearing for any issue or objections na final. And kapag napatunayan na totoo yung mga material allegations and wala ng obligations, tsaka magde-decide ngayon yung commission na i-dissolve na yung corporation, which means i-dispose na lahat ng assets and babayaran lahat ng utang ng company. And katulad ng sinabi ko kanina, hanggat hindi nag-i-issue yung commission ng Certificate of Dissolution, hindi magti-take effect yung dissolution ng isang company or ng isang corporation. Na-discuss ko na kanina yung voluntary dissolution where creditors are affected and not affected. Yung pangatlo is itong dissolution by shortening corporation term. From the word itself, pinapaikli mo yung term o period ng operation ng business. So, if the corporation decided to shorten the term, magkakaroon ng amendment sa Articles of Incorporation and kailangan magpasa ng copy ng amended Articles on Incorporation sa Commission. Upon the expiration of the shortened term, itinuturing na dissolve na yung corporation and it is subject to liquidation. In the case of expiration of corporate term, hindi na kailangang hintayin or mag-issue ng Certificate of Dissolution ng Commission kasi automatic nang magte-take effect yung dissolution on the day of the last day ng corporate term. The last topic under voluntary dissolution is the withdrawal of request and petition for dissolution. The withdrawal request shall be made in writing and dapat verified na incorporators or director or shareholder or even ng member. And kailangan signed by the same number of incorporators directors, trustees, and members. Kailangan masubmit yung withdrawal no later than 15 days from receipt by the commission of the request for dissolution. I-hold ng commission yung request for the investigation. And then after na investigation, they will make a pronouncement that the request for dissolution is deemed withdrawn. Direct joint meetings of the board of directors or trustees and the stockholders or members for the purpose of ascertaining whether to proceed with the solution and issue such other orders as it may deem appropriate. So, a withdrawal of the petition for dissolution shall be in the form of a motion and similar in substance to a withdrawal of request for dissolution. Let's move on to the involuntary dissolution. A corporation may be dissolved by the commission motu proprio or upon filing of a verified complaint by any interested party. This may be grounds for dissolution of the corporation. A. Non-use of corporate charter. B. Continuous in operation of a corporation as provided under Section 21 of this code. C. Upon receipt of a lawful court order dissolving the corporation. D. Upon finding by the final judgment that the corporation procured its incorporation through fraud. E. Upon finding by final judgment that the incorporation is 1. Was created for the purpose of committing, concealing, or aiding the commission of securities violation, smuggling, tax evasion, money laundering, or grand and corrupt practices. 2. Committed or aided in the commission of securities violations, smuggling, tax evasion, money laundering, or grand and corrupt practices, and its stockholders knew of the same. And 3. Repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. Kapag napatunayan na kahit isa sa mga grounds na yan is na-commit ng corporation, automatic na madidissolve yun. And lahat ng asset, kapag nabayaran na yung liabilities ng companies, mapupunta sa government. Corporate liquidation. When we say liquidation, it is the process of winding up the affairs of a corporation and entails the collection of all assets, the payment of all its creditors, and the distribution of the remaining assets among stockholders, if any, in accordance with their contracts or on the basis of their respective interests. After dissolution, the corporation shall nevertheless continue as a body corporate for 3 years, not for continuing the business for which it was established, but for the following purposes: to prosecute and defend suits by or against it, to enable it to settle and close its affairs, to dispose of and convey its property, and to distribute its assets. So during the said 3 years, the corporation is authorized and empowered to convey all its property to trustees for the benefits of stockholders and other persons in interest. All interest which the corporation had in the property terminates, the legal interest vests in the trustees, and the beneficial interest in the stockholders, members, creditors, or other persons in interest, except as otherwise provided for in Section 93 and 94 of this code, na kapag unknown yung isang stockholder, yung contribution para sa kanya is mapupunta sa national government, and except by decrease of capital stock and as otherwise allowed by this code, that no corporation shall distribute any of its asset or property except upon lawful dissolution and after payment of all its debts and liabilities. So, sinasabi lang dyan na kailangan mo nang isettle lahat ng obligation ng company bago i-distribute yung natitirang assets.
Corporate books and records.
So, ano nga ba yung corporate books and records? Ito yung lahat ng books at records ng isang company. Nandito yung information sa existence ng company. So, bakit nga ba mahalaga na may books and records ang isang corporation? Kasi, nandito lahat ng information, lahat ng decision at activities ng isang company. Dito matatrack nila yung mga nangyari and mga amendments and happenings ng isang corporation. Books to be kept. Every corporation shall keep and carefully preserve at its principal office all information relating to the corporation, including but not limited to the articles of incorporation and bylaws and all their amendments. Yung articles of incorporation, ito yung mga document na kailangan sa pag-establish ng corporation. And ito yung pinafile dun sa SEC. Yung bylaws naman, ito yung rules of action ng isang corporation. The current ownership structure and voting rights of the corporation, including yung list ng stockholders or members, intra-group relation, ownership data, and beneficial ownerships. And also, the names and addresses of all members ng board of directors or trustees and yung mga executive officer ng isang corporation. Yung record of all business transaction, lahat ng general journal, general ledger, financial statement, yung mga vouchers, receipts, yung income tax return, and also a record of the resolution of the board of directors or trustees and of the stockholder or members. Ito yung resolution, ito yung mga solution, yung mga suggestion na pwedeng i-apply. Ito yung mga decisions nang napag-usapan sa meeting. Sa copies of the latest reportorial requirements. So, dapat current report yung masasubmit sa SEC. And also, the minutes of all meetings of stockholders or members or of the board of directors or trustees. Dito yung meeting kung kailan, saan, and how it was authorized, yung notice na given, ano yung agenda, kung magde-decision making ba sila, kung may votings ba na magaganap, information sharing or report ng nangyayari sa corporation, and also kung sino yung present and sino yung absent sa meeting, kung regular or special ba yung meeting, lahat ng every act done or ordered done at the meeting. Meron kapag nagdemand naman ng director, trustee, stockholder, or member, pag nagdemand sila or nag-request sila, dapat naka-note din kung anong oras dumating yung isang director, trustee, stockholder, or member, kung anong oras sila umalis, kung yes or no ba yung boto nila dun sa meeting, any motions or propositions, any suggestion na binigay ng mga nandun, dapat naka-record. The protest of a director, trustee, stockholder, or member of any action or proposed action must be recorded in full upon their demand. So, next, books to be kept. Corporate records regardless of the form in which they are stored. So, yung mga records dapat open sila for inspection by any director, trustee, stockholders, and members of the corporation. Pwedeng sila mismo or magdala sila ng isang representative nila like accountant para mas ma-interpret sa kanila yung financial report na gusto nilang inspeksyonin. At reasonable hours and business day. Syempre, dapat working hours nila yun, hindi pupunta ka doon ng gabi. A demand in writing may be made by such director, trustee, or stockholders at their expense. Syempre, kung sino yun ang hingi nung record, sila yung kakargo ng gastos. 4 copies of such records or exempt from said records. And kung ano man yung makukuha nila na information shall remain bound by confidentiality rules under prevailing law. The rules on trade secret or process under Republic Act Number 8293, Intellectual Property Code of the Philippines as amended to Republic Act Number 10173, Data Privacy of 2012, and Republic Act 8799, the Security Regulation Code and the Rules of Court. Syempre, mapapenalize sila kung sakaling lumabag sila. And no right to inspect or demand. Kung kung merong may karapatan manghingi ng corporate record, ito naman yung mga wala silang karapatan. A request party who is not a stockholder, member of corporation. So, hindi sila member. So, aanhin naman nila yung mga reports na makukuha nila, lahat ng datas na makukuha nila. Yung competitor, ba't mo naman hahayaan na makuha niya yon? Or bakit naman gusto niya magkaroon ng copy ng corporate books mo? Syempre may interest siya doon. And any stockholder who abuse rights granted under this section shall be penalized according to section 158 of this code without prejudice to the provisions of Republic Act 8293. And next, any officer or agent of the corporation who shall refuse to allow the inspection and or reproduction of records in accordance with the provision of this code. So, ito yung officer or agent ng corporation na i-refuse or ayaw kang bigyan ng copy for inspection. They should be liable to such director, trustee, stockholder, or member for damages, and in addition shall be guilty of an offense which shall be punishable under section 161 of this code. So, they shall be guilty of an offense which shall be punishable, which is fine ranging from 10,000 to 200,000 if pag injurious or detrimental to the public, yung penalty ranging from 20,000 to 400,000. If such refusal, kung yung refusal na yon ay utos lang or resolution ng isang board of director or trustee, sila yung kakasuhan mo. The liability under this section for such action shall be imposed upon the director or trustee who voted for that refusal. If the corporation denies or does not act on demand for inspection and or reproduction, when you ask the corporate books, sinabi lang nila na ayaw nila ibigay sa'yo, and basta sa anong gagawin mo as a stockholder? Syempre, pupunta ka sa SEC. The aggrieved party may report such denial or inaction to the commission within 5 days from receipt of such report. Kung yung corporation hindi nila binigay yung demand mo na mag-inspect dun sa report na yon, so pupunta ka sa SEC and sila na yung gagawa ng sila yung magkakandak ng summary investigation and issue an order directing the inspection or reproduction of the requested record para magkaroon ka ng record na hinahanap mo. Stock corporation must also keep a stock and transfer book containing all stock names of the stockholder alphabetically arranged, the installment paid, yung mga bayad na subscription at hindi pa bayad, yung mga deadlines, the date of payment of any installment, statement of every alienation, sale, kung binenta mo man yung stock mo, kanino, or transfer of stock made, the date, and to whom made, other entries as the bylaws may prescribe. So, nandun naman lahat sa bylaws yung kailangan. Book shall be kept in the principal office. Saan nga ba dapat nakalagay yung corporate book? Siyempre, dun sa principal office of the corporation. And kung nag-hire kayo ng stock transfer agent, sa office ng stock transfer agent. and it should be open anytime or inspection by any director or stockholder of the corporation at reasonable hours on business days. And rights to financial statements. Within 10 days, a corporation shall furnish a stockholder or member yung written request, and dapat ibigay nila yung most recent financial statement in the form and substance of the financial reporting required by the SEC. Siyempre, dapat kung ano yung bibigyan nila sa SEC, yun din ipapakita sa'yo. At the regular meeting of stockholder or members, every meeting, yung board of directors and trustees, dapat pinipresent nila sa mga stockholders or members nila yung financial report ng operation ng isang corporation. Tapos, pwede din nila ipakita kung ano yung updates ng mga nangyayari during the year, yung kita or yung happenings ng business nila. Dito nga kasama na yung mga financial statement, duly signed and certified in accordance with this code, rules the commission may prescribe. And however, if the total asset or total liabilities of the corporation are less than 600,000 or such other amount as may be determined appropriate by the Department of Finance, the financial statement may be certified under oath by the Treasurer and the President. Kung 600,000 yung total ng asset or liability mo, pwede na siyang maging certified under oath of the Treasurer and the President. Pero paano naman kung 600,000 above yung total asset or total liabilities mo? Yung FS mo, yung financial statement mo, must be audited by an independent certified public accountant na. So, yung mga nabanggit ko, yun yung mga laman ng corporate books and records, together the right to ask for those documents.